And thank you all very much for being here today. My name is Tom Pryor. I'm a staff attorney here at the Public Health Law Center, and I'm really excited to present today on this important topic, regulating tobacco marketing and the First Amendment, constitutional basics that you should know. So my goal is to discuss some basic First Amendment principles and the various tests or doctrines that a court might use in reviewing commercial speech cases or cases in which someone challenges a law that regulates things like advertising or marketing. So the information is necessarily going to be presented at a very high level, but we'll have time for some questions at the end if there are more detailed subjects you'd like to explore. And I'd also like to emphasize here, and I'll do so again at the end of the presentation, that these are topics that we here at PHLC can help you with. And if you work with a city or a county or another government agency, these are absolutely the sort of topics that you can and should be talking to attorneys about, because as you'll quickly see, there's a lot of ambiguity and potential litigation risk when you get involved in First Amendment issues. Before we jump into the content, a little bit more about the Public Health Law Center. We're located at the Mitchell-Hamlin School of Law in St. Paul, Minnesota. And I want to acknowledge that we're on the indigenous homelands of the Dakota people, also known as the Sioux Nation, and that 4 federally recognized Dakota tribal nations remain in this area. We appreciate their ongoing stewardship, spiritual connections, and the lifeways they've developed in these homelands upon which the law school sits. The Public Health Law Center offers free legal technical assistance to all communities, public health advocates, and other partners. We also publish widely on commercial tobacco control policy and offer trainings and webinars like this one. We do not, however, offer direct legal representation, nor do we lobby. At PHLC, we prize equity above equality. Equity is about giving people what they need, which includes understanding barriers, circumstances, and conditions. In an equitable society, something like your race, gender, or sexuality should not be predictive of your health or happiness. And when we talk about public health at PHLC, we try to take a broad view of the subject. We're talking about the social and political determinants of health, the network of policies and factors from housing to education and to the criminal justice system that impact people's health and happiness. And then finally, as a disclaimer before I jump into the content, when I talk about tobacco products today, I'm going to be discussing them in terms of industrial scale commercial tobacco production, not traditional tobacco, which is used religiously, medicinally, and ceremoniously in many different cultures and tribal nations. So my focus, as I mentioned, will be on how and to what extent the government can restrict advertising consistent with the US Constitution. So we know that tobacco marketing is powerful and often very problematic, whether it's offering discounted or low-cost products, or marketing designed to appeal to youth, or placing products next to candy. The industry engages in a lot of practices designed to attract new users, especially young users, and to grow their customer base. So it stands to reason that many public health professionals would attempt to limit these problematic practices through things like marketing bans or other regulations. But unlike a straight-up sales ban, marketing bans encounter a unique constitutional barrier, the First Amendment, which protects freedom of speech. Now, as a preliminary matter, it's important to note that the First Amendment broadly protects speech, which includes things like verbal speech, but also written speech and expressive conduct. The First Amendment's protections are expansive, covering everything from speaking at political rallies or wearing protest armbands to discussing the weather or blogging about TV shows. It also protects commercial speech or expression related solely to the economic interests of the speaker and its audience, typically speech proposing something like an economic transaction like advertising, soliciting, and marketing communications. But while covered by the First Amendment, we'll see that commercial speech does not receive the same degree of protection as core speech. And that's because it takes place in an area in which there's been traditionally more government regulation, and potentially because it's seen as being less essential than core speech. On the flip side, however, the court has noted that commercial speech is valuable because when it's accurate and not misleading, it can and does convey useful information to people. It's also important to note that many states have, within their own state constitutions, provisions that protect the freedom of speech and expression. Oftentimes, these state constitutional provisions have been interpreted to be coextensive with federal protections, so that if a law violates the First Amendment of the federal Constitution, it will also violate the state protection of freedom of speech, and vice versa for laws that do not violate the First Amendment. But it's a good idea to look into your state constitutional protections to ensure that there are no unique rules or wrinkles that you should be aware of. And I should mention here as well, this is the sort of thing that PHLC can help with. Now, before we jump into a discussion of various First Amendment tests, I want to take a step back and talk about how judges make decisions in the first place, because I think that will help make the role that these constitutional doctrines play more clear. So when a judge gets a case, they're going to make their decision based on the facts and the law, we hope, and not just their personal preferences or a coin flip. And by the law here, I mean statutes, regulations, and also rules or precedents laid out by previous courts. And generally speaking, if a higher court has already resolved a similar issue, a reviewing court should try to adopt their same reasoning and come to a similar result. So if the US Supreme Court tackled a case that's a lot like the one a district court in Wisconsin is reviewing, for example, that Wisconsin district court should try to adopt similar reasoning and come to a similar outcome. This comes from an important concept in our judicial system, the doctrine of stare decisis, which means to stand by things decided. This approach to resolving cases creates predictability in the law, and it also constrains judges. They can't just decide whatever they want. Instead, they should act consistent with past decisions. But how does a judge figure out what cases are precedential for the ones that they're reviewing and how to adhere to that precedent? Typically, judges try to make it clear in their written opinions how and why they're deciding the case as they are. And in doing so, they try to explain the rule they're using and the sorts of cases that rule should be used for in the future. So a court won't just search for cases that have the same or similar facts as their own and then just blindly decide their case the same way. The judge will look for rules or doctrines that explain how they're supposed to weigh those facts and what analytical steps they should take to reach a decision. So this is all pretty abstract, so let's try an example. Let's say you're a judge and you're reviewing a case in which a plaintiff slipped and fell on the steps outside of a bookstore and then sues the store owner over their injuries. Now, you could look for cases that have the exact same facts, someone slipping and falling in front of a bookstore, and if you find one, you can just decide it the same way. Maybe the plaintiff won in that previous case, so you could just copy and paste that same outcome here. But in the written opinion of the previous case, the judge probably explained how they reached their decision. Perhaps they explained that the shop owner is liable only if they had control over the steps, if they negligently maintained them, and if their negligence was the proximate cause of the plaintiff's injuries. Now, that phrase would basically be the rule or doctrine for tort liability in these sorts of situations, and you could use that to weigh the facts in your case. So perhaps in your case, the shopkeeper owned the steps and even negligently maintained them. Maybe they were crumbling a bit. But maybe the plaintiff slipped on a banana peel that a previous patron had just dropped on the steps. So it wasn't the shopkeeper's fault because their negligence was not the proximate cause of the injury. It was the banana peel. Now, sometimes it helps me to think visually. So here's an oversimplified flow chart for how a test or a doctrine influences a decision. A rule or a doctrine is a way for judges to know what facts are relevant and how to weigh them as they reach their decision. It's kind of like an algorithm. And it's helpful to understand these doctrines because if you know them, you can predict how a court might treat a hypothetical case in the future. You just plug in the facts and follow the analysis as previous courts have done, and you have an idea or a prediction of what would happen. And as a point of emphasis here, the test or doctrine that is used in the given case will be hugely important for how it's resolved. The facts matter, of course, but the doctrine employed will determine which facts matter and how much. So to understand how a court will resolve a First Amendment challenge to a law, you need to understand which First Amendment test the court is likely to use in the first place. And that's the main point I want to get across during today's presentation, is that a court reviewing a law that regulates a speech will use different tests or frameworks to analyze that law. And those tests can be more or less difficult to pass for a defending jurisdiction. In the constitutional realm, the most common tests or doctrines are different levels of judicial scrutiny. This is basically the idea that, dependent upon the context, a reviewing court might be more or less skeptical that a challenged law is constitutional. Now, sometimes they'll apply a very rigorous level of scrutiny, and so the government would have to clear a high hurdle in order to prove that their law is constitutional. Other times, it will be a low hurdle, and the government will have an easy time defending the law from a constitutional challenge. These levels of scrutiny are used throughout constitutional law and in the First Amendment context as well. And here are those three levels of scrutiny that courts apply to cases in which a government law is challenged based on its constitutionality. They are strict scrutiny, intermediate scrutiny, and rational basis scrutiny. You can think of these levels of scrutiny as existing along a continuum, with the most rigorous being strict scrutiny. If a law triggers strict scrutiny, the government will bear the burden of proving that its actual purpose in passing the law was compelling and that it chose the least restrictive means of achieving that purpose. Strict scrutiny is often called strict in theory, fatal in fact, because it's so difficult to meet those requirements. Now, at the other end of the spectrum is rational basis review, which is a very low hurdle to clear. If a law triggers only rational basis review, it must only be rationally related to a legitimate goal, and really any conceivable goal here, even one that was cooked up by lawyers after the fact, is enough. Intermediate scrutiny sits somewhere in between those two, in that the government's actual purpose must be important, and the means must be substantially related to achieving that purpose. In practice, there's probably a lot of wiggle room in how strict or lenient a court can be within this intermediate zone. So if a law gets strict scrutiny, you can bet that it will probably be struck down. And if a law gets rational basis, the smart money is that it will be upheld. But with intermediate scrutiny, it's much more difficult to tell. Now that's important because most First Amendment specific tests fall in between strict scrutiny and rational basis. And it can be difficult, therefore, to predict how a court will come out on any particular issue. Now, again, these are the basic levels of scrutiny that are used in multiple areas of constitutional law. And as I mentioned, you can think of them as sitting along a continuum. You can also visualize how specific tests or frameworks for assessing First Amendment questions sit along that same continuum. And let's begin with what is known as the Central Hudson test, named after the case from which it originates. As you can see here, it sits somewhere in between intermediate scrutiny and strict scrutiny in terms of how high a hurdle it would impose upon a defending jurisdiction. This test would apply to any situation in which you're restricting commercial speech, like a law banning retailers from displaying tobacco ads in their windows, and it's essentially the default test for commercial speech cases. Now, normally, a law curtailing someone's ability to post a sign on their property would probably get strict scrutiny, but as I mentioned, commercial speech is not protected to the same level as other forms of speech, so it gets Central Hudson scrutiny instead. And while the Central Hudson test is exacting, it's not quite as demanding as strict scrutiny is. I should note that Justice Thomas has challenged that premise in several concurring or dissenting opinions. As far as he's concerned, if a law targets the content of speech or if it's directed at particular speakers, it should get strict scrutiny, even if it's a commercial speech regulation. And I mention that only because even though this would be a fairly radical departure from settled constitutional law, many of Justice Thomas's pet constitutional theories have become the law of the land eventually. I'll come back to this at the end when we talk about drafting tests, but something to keep in mind as I discuss all of these issues. I'm talking about the status of First Amendment law as it sits today in July, almost August of 2024. Talking about this a year from now, and the results could be very different. So if a law triggers Central Hudson scrutiny, the court will ask, if it restricts protected speech, if the law is justified by a substantial government interest, if the law directly advances that governmental interest, and if there's a reasonable fit between the goal and the means chosen to accomplish this goal. So you can see elements of intermediate and strict scrutiny here. The interest need only be substantial, not compelling, but the means should still directly advance the government's interests. Now, in practice, these last two prongs are often the most difficult to satisfy. Most public health laws aimed at restricting tobacco advertising are justified by a substantial government interest, protecting public health. What's more difficult is proving that a law restricting speech directly advances that goal, and that there aren't other means of achieving it that would have a better fit or are more adequately tailored to the purpose. Central Hudson is more of an art than a science, and sometimes when tackling those last two questions, a court will apply an analysis that looks more like strict scrutiny than anything else. So if, for example, a jurisdiction wanted to eliminate tobacco advertising within a certain proximity of schools with the goal of reducing youth rates, the court might require a great deal of evidence to prove that the restriction will achieve that purpose and that other means that intrude upon speech interests less would not be preferable. This was exactly the issue in Lorillard Tobacco versus Riley, a 2001 Supreme Court case in which industry challenged a Massachusetts rule prohibiting outdoor tobacco ads within 1,000 feet of schools and parks. The court there concluded that the restriction was overbroad and would prohibit retailers from providing accurate and potentially useful information to consumers. Importantly, the court qualified that they weren't engaging in strict scrutiny analysis, explaining that the state need not pursue the least restrictive means necessary, but then went on to conduct an analysis that in some ways mirrored strict scrutiny anyways. The court noted, for example, that the rules could have been more tailored to address only those ads most likely to appeal to youths, permitting, for example, smaller advertisements than billboards. The point being, a court has a great deal of room to maneuver with something like the Central Hudson test, and so it's difficult to predict with certainty how any regulation would fare under a Central Hudson analysis, but it certainly represents a high bar to clear for a defending jurisdiction, if perhaps less substantial than strict scrutiny. The next form of scrutiny I want to talk about is O'Brien-Ward scrutiny, which I've named after two famous Supreme Court cases discussing this sort of analysis. And as you can see here, it is a less significant form of scrutiny. It's not as high a hurdle as is the Central Hudson test. This is the framework a court will use when a law restricts behavior or conduct with only an incidental or indirect effect on expression. So from the O'Brien case, a Vietnam-era law making it illegal to damage draft cards was used to restrict expressive conduct because it was employed to punish an activist who was burning a draft card in protest. But the law was upheld because it wasn't directed at that expressive conduct. It was designed to protect against only to preserve the integrity of the draft. So in the tobacco context, this framework could be used for laws that restrict where products can be placed, most obviously laws that eliminate self-service displays of tobacco products. Now, there's definitely an expressive element to product placement. That's why marketers think a lot about what goes in end caps or by the cash register, for example. But you can still regulate where products are placed if the intent is to prevent youth from getting easy access to tobacco products. So yes, the law might incidentally burden the expressive element of product placement, but that's not the goal of the law. If a law qualifies for O'Brien-Ward scrutiny, the court will ask the following questions. Does the regulation further an important or substantial governmental interest? Is the regulation interest unrelated to the suppression of free expression? And would the interest be achieved less effectively without that regulation? You can see how this is a less rigorous form of scrutiny, more approximate to intermediate scrutiny. The government interest need only be important or substantial, not significant. And the policy doesn't have to be the least restrictive means. Instead, if alternatives would be less effective, that's enough to prove a sufficient fit between the means and the end. Where jurisdictions might get tripped up, however, is with that intent element. For example, some jurisdictions have considered enacting laws that would ban placing tobacco products near youth-oriented products like toys or candy. Now, that might not pass or even qualify for O'Brien-Ward scrutiny because it looks more like the law is targeting the expressive element of the conduct, the association between tobacco products and kids' products. And it's not simply addressing access issues. It still might be a constitutional law, but it would probably just be reviewed under the more demanding Central Hudson framework, which, as I mentioned, is the default framework for commercial speech cases. One example that helps explain this comes from the Lorillard case that I mentioned. The Supreme Court upheld a separate law there that prohibited the use of self-service displays and required that tobacco products be placed out of the reach of all consumers in a location that's accessible only to salespersons. Now, the court recognized that there could be a communicative component to product placement, and so the law did implicate the First Amendment, but they upheld the regulation because it was directed at the conduct and preventing minors from accessing tobacco products without first getting proper age verification. And here's where you can see how important it is that the regulation is not directed at the communicative component of the behavior, because the court mused that presumably a retailer could display empty boxes of cigarettes wherever they wanted, because it's not about the box or its labeling, it's about the product and whether kids can get access to it. Now, the most lenient form of scrutiny I'll talk about today is called Zouderer scrutiny, again named after a famous Supreme Court case. This would be used whenever the government requires a speaker to carry an extra disclaimer, disclosure, or warning. Now, such laws don't limit speech, they actually require more of it. And for that reason, courts are often more willing to permit mandatory disclosure laws than laws that ban or restrict speech altogether. So remember, one of the reasons that commercial speech receives less constitutional protection or receives constitutional protection in the first place is because of its value in conveying useful and accurate information to consumers. Disclosures under Zouderer are consistent with that purpose in that they simply require more accurate information be provided. The court applying Zouderer scrutiny will ask if the disclosure requirement is reasonably related to a legitimate government interest, if the disclosure is purely factual, accurate, and uncontroversial, and if the disclosure is unjustified or unduly burdensome. Now, most circuits have identified preventing deception as being a government interest that qualifies for this lower level of scrutiny. And the tobacco industry has argued that preventing deception is the only interest that qualifies. But there's a growing consensus among circuit courts that other interests, like providing public health information, are also sufficient. Now, the disclosure must also be purely factual and uncontroversial. And those 2 points together explain why Zouderer is a lower level of scrutiny and easier hurdle to clear than the other tests we've talked about. Speakers don't have as much of a First Amendment interest in omitting accurate disclosures that correct deceptive communications or provide useful public health information. It's this second prong, however, that can be an easy stumbling block for governments. If a compelled disclosure is too forceful, for example, it might fail this prong because it's no longer uncontroversial. And those are the issues that were at play in the R.J. Reynolds versus FDA case, which was recently resolved by the Fifth Circuit Court of Appeals. And I'm going to spend a little bit of time talking about this in depth because it's a new development in First Amendment constitutional jurisprudence. And I think it's pretty useful for understanding the lay of the land, especially with regards to compelled disclosures. Now, I'll also qualify before I go into this analysis that even though this was recently decided by the Fifth Circuit, it could still be taken up by the Supreme Court, which might disagree with their opinion, and other circuit courts might also disagree and come to different outcomes. So it's not to say that this is the law of the land, but it is a positive development in this space. So this was a case dealing with, as you can see here, FDA required graphic warning labels on cigarettes, in which industry challenged them, saying they don't qualify for Zouderer scrutiny. They should instead be assessed under Central Hudson, and under Central Hudson, they would be deemed, according to the industry, unconstitutional. I'm going to summarize the opinion at a high level, but it generally tackled these major questions which mirror the elements of the Zouderer scrutiny because it did in fact decide that Zouderer applies. And remember, if the warnings didn't apply for Zouderer, it would probably default to Central Hudson, and there's every reason to believe that it wouldn't qualify for that higher level of scrutiny. And so just to kind of give the spoiler here, the court did uphold the FDA graphical warnings because it resolved all of those questions in favor of the FDA. Now, the main question, and I think really where the nub of this case came down to, was this first question of whether the warnings were purely factual and uncontroversial. Now, the basis of the industry's complaint here is that the images were disturbing, emotionally evocative, upsetting, and value-laden. The Fifth Circuit didn't disagree with that premise so much as the conclusion to be drawn from it. The court acknowledged that the images, in fact, could be upsetting, but sometimes facts can upset you, but that doesn't make them inaccurate. Here, the warnings were scientifically supported, and the images mirrored those that you might see in a medical textbook. The fact that they are evocative does not make them controversial or value-laden. The court also ruled that the interest was adequate. Here, the interest was not so much preventing deception, although perhaps there's an element of that, as it was providing useful public health information. So the Fifth Circuit joined this growing consensus among other circuit courts that the interest for Zouderer scrutiny can expand beyond simply preventing deception or misleading advertisements, but can include things like providing important public health information to consumers. And then finally, the court ruled that the warnings were not unduly burdensome. And this is important because these warnings, as you can see here, this is a picture from the FDA's website, can take up to 50% of the front of the cigarette package. But the court said that's not a problem because there's still plenty of space on these packages to provide branding and other marketing information. So this is a pretty important watershed moment for public health communications in the FDA because it potentially means these warnings can go forward. And it also sets a nice little marker for other circuits who are considering state or local graphic warnings for anything, including perhaps sugary beverages. Now, one thing I want to note here is that, as I mentioned, under Zouderer scrutiny, it only qualifies if the disclosure is purely factual and uncontroversial. If, however, the disclosure extends beyond that, it might qualify for Central Hudson scrutiny or even strict scrutiny, or perhaps it could be ruled unconstitutional on almost a per se basis. And that's because the Supreme Court, outside of the commercial speech context, takes a very dim view of compelling speech. It finds that to be almost more offensive than restricting speech. And so if a government is requiring a compelled opinion statement, something like saying smoking isn't cool, that almost certainly wouldn't qualify for Zouderer scrutiny and would most likely be struck down under either Central Hudson or strict scrutiny. There's one final type of law that I want to talk about today, and that would be regulations in which the government is the one that is the speaker, and it is government-funded public health campaigns speaking about the dangers of tobacco use. So I label that as an example of government speech, and I placed it outside the continuum of levels of scrutiny because typically this kind of speech doesn't trigger a First Amendment analysis or First Amendment concerns at all. The government can freely engage in public health communications, and for the most part, doing so does not infringe upon anyone's rights to free expression whatsoever. Now, I covered a lot of ground, and I'm happy to follow up on any of this during the Q&A, but just to do a quick wrap up. In addition to the traditional levels of scrutiny that you find in constitutional jurisprudence generally, strict scrutiny, intermediate scrutiny, and rational basis, you should also know about Zauderer, O'Brien Ward, and Central Hudson tests, and how those apply to different forms of regulations on expression. And for our purposes today, it's not important that you remember all of the nuances and the rules of those, but just to kind of have an idea that those tests exist, and depending upon which test a regulation qualifies for, there might be a higher or lower hurdle for the government to clear if they want to establish that the regulation is constitutional. So what I want to do now, it could be a bit of an interactive thing if people are interested, is to review a couple of hypotheticals and ask ourselves as we look at each of these hypothetical laws, what test might apply if the law is challenged on First Amendment grounds? So I'm going to pull up the chat here from my screen. And so I'm going to be asking these hypotheticals, and if you want, it's completely optional, it's not going to be graded, you can punch into the chat the test that you think would apply to this situation. And for bonus points, you could give an assessment of whether you think the test would say that that law is constitutional or unconstitutional. All right, so let's give this a try. How about a city ordinance requiring retailers to keep tobacco-related products at the back of the store so that they're less visible to shoppers? So the question is, of all the tests that we talked about, which test do you think a court would use to review this sort of a law? And if you want to go even further than that, you could give an assessment or a guess as to whether you think the law would be ruled constitutional or unconstitutional under that test. So you can take a moment and just go ahead and put your answer into the chat if you're willing to share. Okay, so I'm seeing some O'Brien Ward guesses here. Any dissenting opinions to O'Brien Ward? O'Brien Ward and Central Hudson. I think that's definitely the two tests that are at play here, right? My guess is I would say probably this is Central Hudson. And I'm just going to tell you right now, all of my answers are going to have the word probably in front of them because this is a complicated area of constitutional jurisprudence, and there is a lot of ambiguity. And so it's difficult to say with certainty what would happen for any one of these tests. So I think O'Brien Ward is a perfectly good assessment and a good guess. And that's certainly what the drafters were hoping for, because as we discussed, O'Brien Ward is a less significant or less severe level of scrutiny. It's easier to pass. And you could see how they would argue that this is about regulating conduct, not expression, because we're not saying anything about how the tobacco products are advertised or marketed or their labeling or branding. We're just talking about where they can be in the store. I think where this probably falls into Central Hudson, however, is that it does seem designed to attack the expressive element of product placement. It's not that the products be placed away from shoppers to reduce youth access to them. It's that they're supposed to be placed at the back of the store where people won't see them, in the hopes perhaps that people won't purchase them. And so because it is directed at the expressive element of product placement, it probably isn't qualified for O'Brien Ward scrutiny and would default to Central Hudson. I think under Central Hudson, again, it's going to be those last two prongs where this regulation would have the most trouble proving that it directly advances the substantial interest of protecting public health and that the means of advancing it are sufficiently tailored. And likely a review in court would look at the evidence you supply, the logic behind the regulation, and comparing it to alternatives. For example, making it placed behind a counter or outright sales bans. I think because Central Hudson is a more severe level of scrutiny, there is a risk that this would be ruled unconstitutional under it. All right. Let's try the next one. A state law banning all ads, including tobacco ads, from the storefront windows of retailers. So take a second to think about that. If you have a guess as to what level of scrutiny or what type of test would apply, please put it into the chat. And if you want to guess as to whether it would be upheld or struck down, please do so as well. I see a Central Hudson guess. Anybody else? Okay. Upheld as neutral in content, so that's probably O'Brien Ward. Yeah, and so I think those two guesses, again, are right on in the sense that it would fall in between one of those two. And I think they're both great guesses. And again, this is complicated. My assessment is this could very likely qualify for O'Brien Ward scrutiny. And here, I think what's key is that the law attaches to all advertisements, including tobacco ads. It doesn't just isolate tobacco ads. And likely what the drafters would defend this law as a conduct-based regulation that incidentally impacts expression. And the conduct that they're regulating here is clearing the window space for retailers so that a law enforcement officer, for example, can see into the store to make sure that there isn't anything going on in there. And so I think that's the story that the drafters would tell. To try to qualify for O'Brien Ward scrutiny. I think if they succeeded in persuading the court that this isn't about expression, this is about conduct and making sure that you can see through the windows, it would probably satisfy the O'Brien Ward test for that reason as well. So you can kind of see the difference between those first two hypotheticals, where when something is directed at tobacco specifically, it might give you the sense that this is about the expressive element, whereas if it's more universal, you have a better case that it qualifies for something like O'Brien Ward in a conduct-based regulation. Okay, how about a city law that bans retailers from advertising that they should sell discounted tobacco products? And let's assume also that the city bans retailers from selling discounted tobacco products. So you can't offer coupons or multi-pack discounts. And then on top of that, you can't advertise that you are offering coupons or multi-pack discounts. So take a second, think about what test this would qualify for and what might happen. Any guesses? All right, this is a tricky one, so I'm gonna just move forward because I think that this very likely doesn't implicate the First Amendment whatsoever. And now, if you remember the Central Hudson slide where I explained the four prongs, the very first one is whether the law impacts protected speech. And if it doesn't regulate protected speech, you don't have to go through the rest of the Central Hudson analysis because there isn't a constitutional problem. This is a bit like saying you're not allowed to sell cocaine and you're also not allowed to advertise that you're selling cocaine. You're not allowed to solicit customers to purchase this illegal product. And so there's a lot of Supreme Court cases in which they explain that although you generally have the right to engage in freedom of expression, you don't have the right to engage in what are called inchoate offenses, attempt, solicitation, conspiracy, things of that nature, in which you're asking people to engage in illegal conduct. Because the city bans retailers from selling discounted tobacco products, it's probably also permissible for them to prohibit retailers from offering to sell those discounted tobacco products. So it's a workaround to some of these Central Hudson concerns. If you ban a product, it then becomes easier to ban marketing or advertising to buy or purchase that product. A bit of a trick question, apologies. All right, next question. A state law requiring that all e-cigarettes carry a label saying vaping isn't cool. Any guesses as to what test this would get and whether it would be ruled constitutional? And hopefully this is a little bit easier than the last one because I gave it as a bit of an example. Potentially too easy because I did talk about this, but probably this is going to be central Hudson, strict scrutiny, or even a per se prohibition. Because remember, Zouderer scrutiny, which is the other test that this might qualify for, only applies to those disclosures that are purely factual, inaccurate, and uncontroversial. Whereas this is a compelled opinion statement. As I mentioned, something like a compelled opinion statement falls outside of Zouderer protection, and it's going to get that higher level of scrutiny. Because the Supreme Court takes such a dim view of compelled speech, especially speech about a political, social, or cultural opinion, they're very likely to strike it down under one of these approaches. How about a state-funded public ad campaign paying for billboards stating that vaping isn't cool? Take a second and just maybe a quick thumbs up, thumbs down as to whether you think this is okay. If you can find that radial button on your Zoom controls. All right, I'm seeing some thumbs up. And yeah, I do think this is okay. And then in fact, there are no First Amendment concerns whatsoever, because remember, government-funded speech doesn't implicate the First Amendment at all. So the lesson being, you're on very shaky ground, constitutionally speaking, if you require a private party to make an opinion. But it is much safer for the government to express that opinion themselves. How about a state law requiring labels on electronic cigarettes warning that improper use or disposal could cause fires or explosions? So you can either give a thumbs up, thumbs down if you think that's constitutional. If you want to suggest the test that might qualify, please put that in the chat as well. I'm seeing lots of thumbs up. Yeah, so I think there's a good argument for why this would pass constitutional muster, and it would probably be analyzed under the Zouderer test, because again, it is a disclosure about information. Depending upon the nature of the disclosure, I suppose you can make arguments as to whether it's unduly burdensome or not. And the real crux of it would be whether that disclosure is controversial or isn't factual. I think the defending jurisdiction would have strong arguments that indeed improper use or disposal could cause fires or explosions. And while that might be upsetting, sometimes facts are upsetting, and that doesn't necessarily disqualify it from the Zouderer analysis, as the Fifth Circuit explained in the case we talked about. But again, this is all very fact dependent. It's also going to be very dependent upon which court is reviewing it. So it's not to say that this is absolutely going to be constitutional. How about a state law prohibiting tobacco advertisements within 1,000 feet of schools or other youth-oriented facilities? Why don't you go ahead and put into the chat if you think you know what test applies, and then thumbs up or thumbs down if you think it's constitutional or unconstitutional. Seeing some thumbs up. All right, so I think this would probably be Central Hudson, because remember, Central Hudson is the default constitutional test for commercial speech regulations. And this is not obviously an O'Brien Ward territory, because although it's about placement of the advertisement, it's specific to the content of the advertisement. It only applies to tobacco advertisements, not to billboards or ads altogether. And because it's about that expression, it would be analyzed under Central Hudson. Now, what I would do if I were the attorney working with this jurisdiction is I would try to find cases in which there's similar regulations. And as I mentioned, there is actually a Supreme Court case tackling this very same question, the Lorillard tobacco case, in which they ruled it was unconstitutional because it was overly burdensome and the means of advancing your public health interests were not adequately tailored to advancing it. For example, you could have allowed smaller advertisements or advertisements that aren't designed to appeal to children, for example. I give this example as a point of emphasis that this might seem like a very reasonable regulation, the sort of thing that a jurisdiction should be allowed to do. But because the Central Hudson test is so exacting and the standard can be very high, if you get the wrong judge or the wrong court, they could very easily rule that that regulation is unconstitutional under the Central Hudson analysis. But compare that then to a statewide ban on the sale of tobacco products. About thumbs up, thumbs down if you think that's constitutional, and whether you know what tests would apply. Yep, I'm seeing some thumbs up, and I do agree there. This would not necessarily have any First Amendment concerns whatsoever, because you don't have a First Amendment right to sell tobacco products. You don't have a constitutional right to sell tobacco products at all. And I put this here after the previous example to point out that comparison, right? It might seem like a much more significant restriction on somebody's freedom to say you can't sell a product whatsoever than to say you can't advertise a product within 1,000 feet of schools. But as far as the Supreme Court is concerned, sales bans impose upon people's freedoms, their constitutionally protected freedoms, less than a ban on marketing or advertising. Because again, you have a First Amendment right to engage in commercial speech, but you don't have a First Amendment right to sell product. So selling products is actually the less intrusive means of advancing public health than doing a straight up marketing or advertising ban. So what are the general takeaways? Thank you very much for humoring me there and participating in those hypotheticals with your suggested answers and your thumbs ups. So I'm going to end by saying that the First Amendment jurisprudence is complicated, and it's difficult to predict with confidence how a court will treat any particular law. So successful drafters should think strategically. You can't know for certain which test a court is going to apply to your law, as we saw with those hypotheticals. So a strategic drafter should plan for strict scrutiny, even while they're hoping for something like rational basis. And to that end, laws that have been successfully defended often include substantial legislative findings within the law itself or in the legislative record to help bolster the case that the law pursues an important or even compelling interest, and that it's carefully tailored to achieve that interest. This is important too, because the Supreme Court's position is essentially that it would prefer governments to restrict conduct rather than behavior or speech. So a law that limits expression, even if it's just related to advertising, will probably receive more scrutiny than one that just bans a product altogether. And a product ban, as I talked about, might feel more expansive, but if the goal is to reduce use, it might be a better fit from a First Amendment perspective than an advertising ban. And this is doubly important because virtually all areas of constitutional law have been in a state of flux over the last 8 years or so. So even though the jurisprudence over commercial speech is relatively settled as of right now, there's no guarantee that it won't undergo seismic shifts in the future. So even if you think you can satisfy something like Central Hudson test, you might eventually be facing something that looks more like strict scrutiny. And on that note, and as I mentioned at the beginning, these are the sorts of issues that PHLC can help you with to provide further education information. And these are absolutely the sorts of issues that you can and should seek legal advice from an attorney if you plan on regulating advertisements or marketing. So if you take nothing else from this presentation, I hope it's that you should proceed with caution when crafting policies that target marketing and advertisements, and to consult with a qualified attorney early and often. So thank you very much for your time and attention. I appreciate your participation. I think we have maybe a minute or two for questions. I'm happy to stick around if other folks would like to, but otherwise it's been a pleasure.
Thanks so much, Tom. Such a great lesson here. We do have a few questions. We'll ask a few during, if people can stay on, we'll go through a few. One question that came up is, would these same rules and standards apply to regulation of other products such as alcohol?
Yes, that's a great question. Generally speaking, these constitutional rules that I talked about apply across all issue areas. That being said, there's probably going to be different cases that you look to for precedent in determining whether this specific regulation would or wouldn't pass constitutional muster. But Zouder, O'Brien Ward, Central Hudson are used for tobacco ads. They're used for liquor marketing. They're used for sugary drinks, the gamut. Great question.
Thanks. Another question we have is regarding public. So who firms, specific attorneys, specific organization, who argues on the side of public health at the Supreme Court? Is it only the government? And then only if the government has decided the public health interest is defensible?
Yeah, also a great question. And it would depend on which law is being challenged. And so typically, the First Amendment only applies as against the government. Actually, if you read it carefully, it only applies as against Congress, but it's been incorporated against the states through the 14th Amendment, a lesson for another day. So private individuals don't infringe upon each other's First Amendment rights. It's only the government infringing upon your First Amendment rights. And so when a law is challenged, it would be whatever attorney organization represents that government agency. At the federal level, it's typically the Solicitor General's Department. At state levels, it's typically the Attorney General's office. If it's a city or county, there's likely a city or county attorney. Sometimes they'll outsource that sort of defense to a private firm who has more experience defending these sorts of lawsuits in the higher levels of the courts. But public health organizations can and do participate as amicus parties in these. And so PHLC and other organizations have done this quite frequently, in which you draft a brief to the court explaining what you think it needs to know about this and what it should do to resolve that question. You just don't get to argue the case and participate as a party. You're a friend of the court, providing information to them.
Excellent, thanks, Tom. One other question has come up is, has anyone ever challenged the prohibition on lobbying for organizations that receive federal funding for infringing on their rights to free speech?
Oh, that's a very interesting question. I don't know the answer off the top of my head. I do know that there's a lot of very interesting cases about lobbying restrictions from a First Amendment basis, and whether state provisions in particular that require things like lobbyist disclosures and registration are constitutional if it applies to people who are basically just private citizens who are petitioning their government. But I don't know the specific answer to that. It's certainly something that we should look into, though.
I know we are going a few minutes over time. Tom, is it okay if I share your email in the chat?
Yes, please do. Thanks. I think I had a slide
Yeah,
with contact
slide there.
information
I'll just
that
re-put it in
I
the
lighted
chat.
over.
Yeah, so we don't have to reshare the screen. Just since we are going over time, I want to, please feel free to reach out directly, and we can, we had a couple other questions here that we can try to address post-webinar via email.
Great. Well,
Yeah.
thanks so much, everybody. And we'll look forward to answering some of your questions through email if you have them.
Thanks for joining us today. Bye, everyone.